Welcome to today's lecture in the year-long lecture series on race and regulation, organized by the Penn Program on Regulation here at the University of Pennsylvania Law School. I'm Kerry Colanisi, the director of the Penn Program on Regulation and a professor at Penn Law. This lecture series on race and regulation focuses on the most important task for every society: ensuring equal justice and dignity and respect to all people. Our entire series is co-sponsored by the Penn Law Office of Equity and Inclusion, and today's lecture is co-sponsored by the University of Pennsylvania Asian American Studies Program, the Center for Latin American and Latinx Studies, and the Center for the Study of Ethnicity, Race, and Immigration here at the University of Pennsylvania. The lecture today, entitled Race, Citizenship, and Political Inequality, will be delivered by Professor Ming Hsu Chen of the University of Colorado Law School, although she's also a visiting professor at this time at the University of California, Hastings College of Law. At Colorado, she holds appointments in law, political science, and ethnic studies. And she is the founding faculty director there of the Immigration and Citizenship Law Program. Professor Chen brings an interdisciplinary perspective to the study of race, immigration, and the administrative state. And her writing appears in leading law reviews and social science journals, and most recently in a book entitled Pursuing Citizenship in the Enforcement Era, published by Stanford University Press. At the conclusion of Professor Chen's lecture today, we should have an opportunity for questions from the audience. To submit a question, all you have to do is click on the Q&A button at the bottom of your Zoom screen, and then I'll be able to see your questions and will ask as many of them as time allows as I can to Professor Chen. With that, and without any further delay, it's my distinct privilege to turn the screen over to Professor Chen to speak on race, citizenship, and political inequality. Professor Chen?
Thank you so much, Professor Colanisi. And thank you and congratulations to all of you in the Penn program on this race and regulation series. I've been eagerly listening to it myself, and I'm very pleased to be able to participate in it today. So my focus today is going to be on political misrepresentation, which is the reality that there is political inequality for Asians, Latinos, and other non-citizens in America. There have been rapid demographic shifts that have increased the population of minority voters as well as non-citizens. And those changes have been met with numerous regulatory challenges that systematically thwart the possibilities for representation. So I want to make that my focus. And the research that I'll be basing my talk today on consists of a two-part series of essays on political misrepresentation. One published in the NYU Law Review on political misrepresentation, specifically in the census. And then secondly, a piece in the Colorado Law Review that focuses on this issue specifically in the area of voting. Now, in this work, I start out by saying that citizenship consists of being a member of a political community. And being part of a political community entails participating in a democratic society. Now, this takes two forms. The first is voting rights, and that fosters direct participation. It's probably the most familiar to anyone who thinks about political participation. The second is indirect representation, such as when members of Congress cast votes on behalf of the people in their districts. Now, that representational equality requires that the elected representatives look out for all of the people in their district, regardless of their race, and maybe more controversially, regardless of their citizenship status. Representation permits people who cannot vote or do not vote to have their voices be heard. This broad representation is based on the notion that legislators have a responsibility to represent all persons in order to protect the community's interest. And those direct and indirect forms of participation are, of course, intertwined because individual voters select the officials who will go on to represent them. And yet, representation is distinct from voting in other ways, including that it is not restricted to citizens in the way that voting is. There are a number of efforts to exclude non-citizens from politics, as there has been to exclude racial minorities from politics as well. And in these remarks, I'll take each in turn. I'll start by giving you a little more information about the demographic diversity that presents these challenges to representation. And then I'll look at two different kinds of regulatory barriers. One are voting laws that lower participation for Asian Latino voters. And then also I'll look at policies that change the formula for representation in ways that would skew the coverage of non-citizens as well as those Asian and Latino voters. Finally, I'll look at why the systems we have are not working, why courts are so unreliable as protectors of non-citizen rights. And in closing, I'll make what might be a surprising suggestion that we need to turn toward politics to enhance representational equality for these vulnerable groups. So let me start with the demographic challenge. Now, during the pandemic, migration and population growth slowed. The non-white population, however, has been growing even faster than predicted during this time. The data from the census in 2020 has come back in the last few weeks, and it's revealed that the Asian American and Latino population is vastly expanding. The population is also becoming younger, and that also has a skewing effect on representational equality. Now, this has implications for political engagement. For example, Asian Americans are naturalizing and engaging in politics at a higher rate. And we could see that in the 2020 election. Voting was 59% in 2020, which was up 10% since 2016. And that rise in voting consisted almost entirely of new voters. For the Latino population, naturalization and political engagement also continues to grow. Participation went up by 6% in 2020, reaching 54% as compared to the 48% in 2016. And the growth was concentrated in highly consequential states like Arizona, Florida, and Texas. These are not only populous states, but states where we've seen a lot of partisan shifting. Now, given these demographic changes, non-citizen political influence ought to be coming, but there are several barriers to translating this increased potential for power into actual political power. And that's what I want to turn to next. Now, we'll start by looking at voting laws that present a barrier to Asian, Latino, other racial minority voting, and of course to non-citizen voting. And we know that there's a long history of voting in the United States that covers this legacy of political inequality. There have been formal barriers to voting, such as the disenfranchisement of individuals deemed outside the political community because they were slaves, because they were women, because they were poor, because they were disabled, or because they were illiterate. And those historical efforts to suppress political participation are continuous with the contemporary efforts to put up barriers for Latino and Asian voters. Now, this consists both of the formal barriers to voting, such as voter identification laws, and the closely related voter challenger laws or voter purge laws. And they also consist of more informal barriers that uniquely affect these groups, such as language barriers, or other challenges recognizing surnames or barriers to naturalization. So let me start by talking about the rules that impact the eligibility to vote. And then we can turn to some of these softer barriers as well. Now, the eligibility to vote that is premised on citizenship might seem so taken for granted that we don't even think about it as a barrier. But federal laws do prohibit non-citizens from voting. There's no equivalent prohibition for state and local voting, but 5 states have gone out of their way to enact laws or have amended their state constitutions to explicitly state that non-citizens cannot vote. Those 5 states are Arizona, North Dakota, Colorado, Florida, and Alabama. Now, to many people, that won't seem like a problematic barrier, but it is a barrier, and it's worth noting that it hasn't always existed. There have been times in US history where there has been US non-citizen voting. Now, what we've been hearing about a lot more in the news is not a questioning of the eligibility to vote, but the proof that has to be furnished for eligible voters to be able to, in fact, cast an effective ballot. Now, voter identification laws have also been available since Jim Crow. They gained prominence in the wake of September 11th, when Congress passed legislation that required voters to show ID. And they also passed additional legislation, the Real ID Act, that tightened up the requirements on what kinds of IDs would count. Most notably, state identification cards that have to include citizenship status, and penalties for voters who are using non-compliant state IDs. And they might, for example, have their ballots only count provisionally on election day. As of January 2020, 34 states have voter identification laws on the books. 19 of those include photo identification requirements, and others are documentary proof of citizenship or proof of residency. And empirical studies show that these proof requirements really do work. They really do suppress voting, especially for newly naturalized citizens. So more specifically, studies have shown that voter identification laws can depress racial minority voting while exerting a negligible effect on white voter turnout. So for Hispanic and Latino voters, who are the largest foreign-born group in the United States, the turnout rate is 7.1% lower in states that have strict voter ID laws than in other states. For Asian American voters, the fastest growing foreign-born group, the turnout in strict states is 5% lower. But by comparison, for white voters, putting in a strict voter ID law only reduces participation by 0.2%. So there's a real disparity in the effect of these laws depending on the people that we're talking about. And again, mind you, these are all people who are in fact eligible voters. This is just about proving that eligibility. Now, there are also some voter challenger laws that allow individuals to challenge a different voter's eligibility. Essentially, this is sort of a private right of action or sort of a private law enforcement action. Now, those laws are intended to ensure the integrity of elections, but they can be used by overzealous poll watchers to harass or intimidate minority voters. For example, in Georgia, there were 3 residents in a particular election that challenged 3/4 of the Latino voters in that county, alleging that the registered voters were not citizens when in fact they were. In the same year in Alabama, poll watchers in a city council race where there was a Vietnamese American candidate challenged the Asian American voters, saying, "We figured if they couldn't speak good English, they possibly weren't American citizens." Right? So those are some of the risks of raising the barrier so high for those who are in fact already eligible for citizenship, but might just have a harder time proving it. Now, there's another set of barriers that I want to speak about that are not directly challenges to voting, that direct form of participation, but are challenges to indirect participation in the form of representation in Congress and electoral politics. And there are 2 in particular that are of note. One is a set of rules that have tried to exclude immigrants from apportionment and redistricting. That is the number of seats that are given to a particular state in Congress before the lines are drawn to divvy up those particular seats. Those efforts famously have included the effort under the Trump administration to order the Census Bureau to actually subtract the undocumented population from the 2020 census count. Biden rescinded that executive order, and the Census Bureau has foregone a report on undocumented population. But nonetheless, state challenges to this idea of using the total population, including non-citizens, do continue. And we're seeing a round of redistricting that includes states like Missouri, who for the first time are proposing to use citizen voting age population, or CVAP, instead of total population. And if you want to be able to see the effect of that, you can see in this map right here what the estimates were going into the 2020 census of the effects of shifting population, and in particular, the exclusion of immigrant voters. Now, Evanwell versus Abbott was a Supreme Court case that actually settled that total population may be used for congressional seating, but it didn't say that it must. And that's why we still have an open question about whether or not the formula can be changed from the more inclusive one of total population to the less inclusive, which would look at just the citizen voter age population. The theory of why you might include total population is a quote directly from the Evanwell opinion: persons, not voters. That's the theory of the Constitution. Persons, not voters, have an important stake in many policies. For example, children, their parents, their grandparents, all have a stake in a strong public school system. Let me move to the second set of challenges. And these deal with not the complete exclusion of non-citizens from the census count that goes on to determine apportionment, but the undercounting of immigrants in the census. Now, in a regular year, the Census Bureau always has trouble counting everybody. We have a large country, we have a lot of people, and there are certain groups that are predictably hard to reach. That's a regular year. This has not been a regular year. During the pandemic, there was a switch to online surveys. There was less door-to-door outreach. There was a lot of political wrangling to end the count early, even though there had been delays getting the whole process going. Now, the results were unexpectedly good overall. The census participation actually remained pretty high in 2020, but it was less high for the vulnerable groups that we're talking about today. The Census Bureau showed the non-response rate was highest among groups that typically would have required interviews to follow up, and those interviews were suspended during COVID-19. Just in the last 2 weeks, there have been statistical reports on the census data that was initially released that show really troubling results. While the overall population total was relatively accurate, the counts specifically of Hispanic, Black, and Native American minorities were skewed. And that's because there's a statistical technique of imputation that can correct for the overall population, but didn't actually hold constant demographic variables like race. And so the result of that is that the census ended up undercounting the Latino population by 4%. It ended up having a response rate of 12% less than would have been expected. And even though the citizenship question that had been put onto the questionnaire right up until the Supreme Court stopped it just weeks before census administration began, even though that question didn't go on, there may still have been a chilling effect on participation in the Latino community in particular, in families that have mixed status, where one individual might be less comfortable participating or opening their door to a census worker if they knew that there was someone else in their home that might be undocumented, which of course doesn't make them ineligible to be counted, but might open them up to the scrutiny of the federal government on other affairs. Now, to be fair, the pandemic stress might not have been prevented, but the political wrangling that happened behind this census effort was purposeful. There was proof of political manipulation and cover-up in the Commerce Department versus New York case that went to the Supreme Court. And in that case, the Supreme Court found that the effort to add that citizenship question was arbitrary and capricious under the Administrative Procedure Act. And the census challenges occurred alongside other citizenship battles, which suggests that this was not inadvertent. There were battles over birthright citizenship, the definition of a constituent on the naturalization test in the immigration agencies, and the false premise of non-citizens and dead people who were voting in the 2020 election. There have been critical histories looking at the longer practices of census taking, and they do show other attempted exclusions, many of which the Census Bureau has tried to resist, but some of which have led to abuses, such as the use of census data to target Japanese Americans for internment. Those really do go to hurt community trust, and that goes to some of that chilling effect that I was speaking of. So with these problems that I've talked about, you would think that we have institutional solutions. Of course, participation and voting are things that we've cared about as a country since the founding days. And yet many of the institutions we have in place that are meant to deal with these problems actually don't work very well for Asian voters, Latino voters, or for non-citizens. And so I want to focus on two in particular. One, the judicial critique, the failure of courts that we assume will be able to protect these individuals, and how that might then drive a need to look elsewhere, to look more toward politics, as I said, and the barriers that we have making the mind shift to include non-citizens in that political vision. So starting by talking a bit about a common conception, again, one that might seem so widely believed that it's not even questioned. And that is the idea that non-citizens are not and should not be part of the political community. Again, this isn't necessarily a racist view. This is a really common conception, and it's reflected in the requirement of citizenship to be eligible to vote in federal elections. On the one hand, immigrants aren't citizens, so they can't vote. But on the other hand, they are persons. And as I said, they can be represented in Congress and in the census count. So that does seem inconsistent. There's a tension there, but you could resolve that tension in two ways. One, it could be that the right to vote is not exactly the same as the right to representation, right? And citizenship membership theory says that citizenship has multiple layers. So non-citizens can be legally outsiders, but that doesn't mean that they're outsiders in every sense, right? Politically, socially, economically, they can be insiders at the same time that legally they are outsiders in the sense of being non-citizens. And even if they are legal outsiders at the border, it doesn't mean that they have to be considered outsiders in schools, in other domestic affairs. Jennifer Chacon has said that courts sometimes get this right in areas like the census and education, but routinely they get it wrong. So the heart of this judicial critique that I want to lay out is that this confusion isn't fixed by the way that the Equal Protection Doctrine and other civil rights laws operate in an effort to protect minority voters. Whether a person is considered an insider or an outsider is really consequential because a lot of rights and responsibilities are assigned according to that legal status, the one that makes you an outsider or an insider. But courts that are confronting the denial of these rights have gotten it routinely wrong in a series of cases concerning the political functions that are performed in a community and the eligibility of non-citizens to be part of those functions. Now, again, backing up to basic principles, constitutional rights do apply to citizens and non-citizens. The 14th Amendment applies to persons. That's consistent with some of the seminal cases like Yickwo, Graham versus Richardson, and Plyler versus Doe. These are all cases that applied strict scrutiny to non-citizen discrimination by states under the Equal Protection Clause. You have analogous provisions for civil rights laws as well. Yet at the same time, there are cases that say that political rights ought to be reserved for citizens alone. And that means that the government can discriminate against non-citizens constitutionally. And again, the common sense example is voting. And yet there are many other examples of political inequality. And I'll just focus on one, which is public employment. There was a case in 1973 called Sugarman versus Donald, where the Supreme Court held a New York statute that denied all non-citizens the right to hold civil servants' jobs was unconstitutional. And the court reasoned that non-citizens were a prime example of a discrete and insular minority, and that classifications based on alienage were subject to close judicial scrutiny. But in dicta, the court said what came to be known as this political function exception, and it laid the groundwork for states and local governments to pass a number of laws that would exclude non-citizens from participation in self-governance. That included exclusions from the police force, from being a school teacher, and even from attorney licensing. And there are still barriers to non-citizens serving on juries. So we have to remember, though, that these laws, these public function exceptions to constitutional protection, are supposed to be exceptions to the more general rule of equal protection, and they're supposed to be a narrow exception. And in fact, I would say, this is my critique, that the cases are ironic and wrongly decided. It's the very same thing that seals off non-citizens from judicial protection. It's the same thing that seals them off from political protection. So you have a double harm, right? One of the reasons for the Equal Protection Clause and excluding the strictest scrutiny to racial minorities is this idea of protecting them because of their lack of political recourse. And when you think about that phrase of a discrete and insular minority, I can't think of a more paradigmatic case than non-citizens who literally can't vote and have no political recourse. So based on that understanding, I think you either have to say non-citizens get higher protection from the courts, or they should not be removed from politics, or maybe you should even say both of those things. But instead, we've chosen the route where courts don't extend that heightened protection, and non-citizens still don't have direct access to political participation. Now, this rights-based framework that I pointed out, the one that we think of as the first go-to to protect minorities in politics, are not the only pathway. What we've seen is more limited success with procedural tactics, including the Administrative Procedure Act. Now, weaknesses in these substantive protections have allowed us to instead look at neutral procedures in order to be a tool for raising the floor, right? Having a certain level of basic fairness that allows persons to participate in society. Now, there's been a really significant convergence of immigration law and administrative law over the last 10, 15 years. And in fact, that's actually why I study administrative law now. I was an immigration law scholar first. And because of the way that the policies have developed and the way that case law has developed, I've developed this deeper interest in administrative law. And there are dozens of examples of the APA being used successfully to challenge agency actions on immigration. Two really recent cases concern the APA's prohibition on arbitrary and capricious agency action in the Census Bureau case, Commerce versus New York, that I just explained to you. Another was with President Obama's Deferred Action for Childhood Arrivals program, otherwise known as the DACA program. That program first went into place in 2012. It was expanded in 2016 and then immediately enjoined in court. When President Trump came into office, he rescinded the program. And then Biden rescinded the attempted rescission. And so in 2020, the Supreme Court relied on the same section, the arbitrary and capricious clause of the APA, to invalidate the Department of Homeland Security attempted rescission of DACA. The court found that the action was made based on impermissibly post hoc rationalizations, and that the DHS had arbitrarily and capriciously ended the program because they did not adequately account for the reliance interests of the students, the DACA students, the schools they attended, the employers who might eventually hire them. So that concept of reliance is one that got picked up by the APA when it otherwise may have been dropped under equal protection. So let me turn now to my political critique, because this starts to lead us to an actual solution, right? If the fixes that we think are supposed to work aren't going to, where can we look instead? And my second critique, this political critique of this idea that non-citizens are political outsiders, cuts deeper than the judicial critique in many ways. I'm going to say something bold, and that's to claim that non-citizens deserve to participate in politics. And this goes to a more inclusive notion of representation. It's the idea that voters and non-voters, which means children and adults, as well as non-citizens and children, and non-citizens and citizens, are all members of a political community and ought to receive equitable and effective representation. So non-voters, as we said, of course, are not voting. They get proxy representation, right? And you're familiar with the idea of children having proxy representation from their parents. The analogy can carry over to the non-citizen context, perhaps with mixed status families that invert the relationship, right? Where the immigrant parents might be represented by their citizen children. You might also see it in communities that have a lot of immigrants in them, diverse communities, gateway cities like New York or San Francisco. Those are places where you have immigrants and citizens who have a shared or a linked fate. That is to say, they have shared community interests. Now, this fits together with the problem I had with the political function exception, right? Not only does the reasoning for allowing non-voting need to carry over to representation, it might be even more important to preserve that political representation to avoid that double harm that I described. If we think about discrete and insular minorities, not just as another minority group that a court has to step in to rescue, but a reason to enhance access to the political process, you have the nub of my suggestion that we need to find some alternative channels to enhance political power for these groups. So how do we do that? Let me turn to 3 proposals here for regulatory changes that would enhance non-citizen equality. And they are civic engagement, representation, and non-citizen voting, at least in local communities and elections. So I'll take those each. Starting with civic engagement. Political representation for non-citizens takes hold in the individual right to civic engagement. And that means rights for individual people to speak and to engage in civic organizations. In the realm of institutional politics, that also extends to a right to contribute to political campaigns that have a direct bearing on who will represent you in politics. Well, currently there is a federal statute that prevents foreign nationals from making campaign donations in any federal, state, or local election. For the familiar reason that we've been talking about, those are things that relate to democratic self-governance, so they're usually considered outside the purview of things that non-citizens would have access to. But those same regulations permit permanent residents, those who are lawfully living and working in the United States, to contribute to campaigns in order to protect what the courts have considered core political speech and the act of being able to contribute to a campaign and select an elected representative who will go on to represent your interests. Now, while the outcome in the cases that have reviewed this regulation are maybe good, or at least they're inclusionary in the way that I'm seeking, the reasoning, I think, is incomplete. Apart from being core political speech, another justification is that permanent residents are stakeholders in these political communities. And by virtue of being stakeholders, they ought to have a right to engage. That relates to the same reasons that there should be a right to be counted for electoral representation under the census, and also the right to petition in Congress, something that people have been writing more about, most recently Dan Carpenter in a great new book, Democracy by Petition. Let me turn secondly to representation. It'll elaborate on this idea. There are other regulations that could expand political power in direct ways. So aside from being able to be engaged in politics generally, being able to give money to select someone else to represent you, you could consider allowing non-citizens to hold public employment and maybe even to hold elected office. Now, right now, the Constitution expressly forbids non-citizens from holding federal elected office. And many of us are familiar with this because we've seen battles, sometimes ugly battles, about the citizenship status of Barack Obama, Ted Cruz, Kamala Harris, John McCain, right, across the political spectrum. So we're very well aware that you have to be a citizen to run for high-level public office. But in addition to that eligibility requirement and the state restrictions on civil servant jobs that have been permitted by the Supreme Court, there are federal appropriation bills that have prohibited the use of federal funds for the compensation of non-citizen government employees. This happens to me every year with my law students. I will have excellent green card holders, permanent residents who have spent the bulk of their life in the United States and are not eligible for a federal clerkship because of this very appropriations limitation. It's only very narrow categories of non-citizens, including lawful permanent residents who are applying for naturalization and refugees who have declared an intent to naturalize, who can be compensated as a federal government employee. So naturalized citizens, again, those who were formerly immigrants and then naturalized and then become eligible to run for office, they hold an extremely small percentage of offices nationwide. And maybe it's important to allow immigrants to be represented in the federal government by others who understand immigration. That's the premise of a nonprofit called New American Leaders Group that essentially is a boot camp for new leaders who come from immigrant populations and have become eligible for elected office. And it might even be time to reconsider that prohibition on civil servant jobs or the statutory and regulatory limitations on non-citizen employment with the federal government. Again, all of those would complement the right to representation by elected officials and redistricting that create more of a right to an effective vote in Congress. Now, let me turn to the last, and this is probably the most contentious. It's the issue of non-citizen voting. So as I previously said, non-citizens are not prohibited from voting in states and local elections. At the federal level, they are, and with some very small exceptions, if they do, they can be punished with fines, imprisonment, or deportation. Now, at the state level, there's no flat prohibition, but those 5 states I mentioned have amended their constitution to preclude non-citizens. But those 5 states don't speak for everyone. There are other jurisdictions who have taken the opposite approach, specifically allowing non-citizens to vote in local elections. Now, none of these states has taken the step of actually amending their constitution to permit non-citizens to vote. But a growing number of cities and counties across the country have enacted some form of non-citizen voting. There are 11 jurisdictions in Maryland, maybe not surprisingly represented by Jamin Raskin, who was previously a political scientist and probably knows these theories of membership that I've been talking about. But in those jurisdictions in Maryland, they allow all non-citizens to vote in all local elections, regardless of whether the individual has lawful status. In New York City, it permits those who have work authorization, like lawful permanent residents, refugees, asylees, and DACA recipients, to vote in municipal elections. And San Francisco permits non-citizens to vote regardless of lawful status. So that means, again, DACA, but also undocumented immigrants, but only in school board elections if the non-citizen has a child in that school district. This again echoes the history of voting in the United States. Over 40 states and territories have at some time given non-citizens the right to vote, and that started in the early years of the nation. But there was a retreat in the 1900s that led to states taking that back piece by piece. Let me return to my caveat. Non-citizen voting is a very small phenomenon, despite fear of widespread and fraudulent voting from non-citizens. And support for the kinds of measures I've mentioned in these progressive spots like New York City, San Francisco, and the 11 different places in Maryland are not universal, and they probably won't be enacted universally across the country. And opponents might be anti-immigrant, or they might be people who hold that common belief that I've come back to, that you should accept the duties of citizenship before being allowed to vote, or even that making voting too accessible will lessen the incentive to naturalize and become a citizen in the first place. Again, common view, not a racist view, even if it happens to be one that I disagree with. And I already gave one reason that I disagree, and that's that the failure of courts to protect minorities and non-citizens. But the second of those is this failure in institutional politics to effectively include non-citizens and minority voters. So let me make this my last point. In a nutshell, I believe that non-citizens should be able to participate in politics because they have a stake in their community, and they can promote public policies that are beneficial to themselves and their entire communities. Now, as communities across the nation are becoming more diverse, including more racial minorities as well as non-citizens, legislative strategies for empowering those individuals have become less effective for political equality. So we need to look for alternatives by highlighting this lost ideal of a political community. Guy Uriel Charles has been part of this speaker series. He gave the distinguished lecture that also just published its remarks in the last week or so. And he described 5 different approaches to thinking about race and power in American democracy. I paraphrased and boiled them down to 3. The first of those is the idea in federal politics of judicial deference to state sovereignty over electoral affairs. The second is the idea of racial inequalities being a special exception to the political order, therefore requiring only the narrowest exceptions. But thirdly, and this is the one he advocates and that I would agree with, this idea that racial inequality and political inequality are mutually symbiotic. That is, they rise and fall together. And that third approach is what leads to corrective measures that can achieve a more inclusive political order. I think that that ambition is captured in the Voting Rights Act. But as those who have been watching this series know, the Voting Rights Act has been hobbled by the court's hostility toward race-conscious tools that would correct political inequality and a certain blindness to the disparate impacts of gerrymandering. So where can we look instead, right? How do we achieve this political order if it's not going to be in the Voting Rights Act? One idea is in this idea of communities of common interest. That is a concept that's been protected under Section 2 of the Voting Rights Act, which is still intact after Shelby County. There's not a strict definition or a settled definition of a community of common interest, but it generally refers to a group of people in a specific geographic area who share common interests that are linked to public policy issues. That could be economic, that could be historic, that could be cultural, but there could be other bounds. Now, if a group can represent itself to a redistricting commission and make the case that they do have a shared characteristic that entitles them to be kept together in a single district, they can keep their community of interest intact and have more political influence, essentially wielding a sword in politics that they wouldn't otherwise have, and better representation, a shield from the kinds of challenges and inequalities that we've been talking about. And we've seen that in instances where you have cross-racial coalitions. For example, you might have a community with a poor community that includes Asian, Latino, Black members that would otherwise be cracked by redistricting. And by asserting a shared interest, you might be able to hold together as a community. You could also use it to coalesce common interests within a racial group that is itself diverse. And so elsewhere, I've written with political scientist Taeku Lee that communities of common interest can be used to bind together, for example, Asian American communities who share languages, immigration histories, and experiences with discrimination or underrepresentation in politics, even if they may not be as geographically compact or as cohesive along partisan lines as other racial minorities whom the Voting Rights Act was initially designed to protect. There's other techniques that you could use to extend this idea of a more inclusive political order that go beyond legal status. So if not this communities of common interest idea, municipal voting on the basis of residence in the school district, financial stakes on a parcel of land, reliance on the same water resources, a shared risk of wildfire in Los Angeles. These are all things that have managed to succeed. These are all stakes that are borne by all of the residents in the community, whether they are US citizens or not. And acknowledging them means acknowledging that the immigrants live and work, they start families and businesses that are parts of these communities, and that the US citizens rely on them as well. So any harm to the US citizen affects the whole community, non-citizen and citizen alike. Calling for racial minorities to turn toward politics might again seem surprising. Most people would probably most people who are concerned about immigrants would probably not trust politics since it has excluded non-citizens from participation for so long. There might be problems of feasibility with what I've spoken of, given that race and immigration policies have been quite polarized in Congress. And in particular, there might be these persistent structural limitations in the present system that relies on political branches to protect non-citizens, even though there's a lack of political accountability to a non-voting or a minority population. But nonetheless, we could expand this conception of political community to be more inclusive, and we can have a more robust articulation of the civic duties and shared values behind them. I've listed a few examples of states and localities that have tried to do this through local voting and this idea of communities of common interest. Again, it's probably not going to happen everywhere across the country, but nationally, the US does permit non-citizens to pay taxes, to serve in the military, to give to campaigns, and to be counted for electoral representation. And so it means that there's potential, right? It has happened in some places and at some times. And while regulations to expand the political community might currently be out of favor, it is something that could come back into favor. Thank you.
Thank you very much, Professor Chen. That was a really a tour de force of the issues and landscape about political inequality, race and immigration in the United States. So thank you for that tremendous overview and in-depth and insightful discussion. And thank you too for mentioning the lecture by Professor Guy Charles at Harvard Law School As you said, the regulatory review, which is put out by the extraordinary students here at Penn Law, who are members of the staff of the regulatory review, just published that lecture this week, and you can go to our website, www.theregreview.org, and find it there. You can also go to the Penn Program on Regulation's YouTube channel, where all of the lectures in this series are found, and you can watch Professor Charles' lecture there. As Professor Chen mentioned, that was our 2021 Distinguished Lecture on Regulation that Professor Charles delivered. As it happens, and this will be my last commercial announcement, as it happens, our 2022 Distinguished Lecture on Regulation will be scheduled for this coming Monday, March 28th at noon, with the director of the Consumer Financial Protection Bureau, Rohit Chopra, who will be speaking on reining in corporate recidivism. And I encourage anyone interested to sign up at our website, penreg.org, for that lecture as well. But let me turn to questions and invite questions also again from the audience. Please post those in the Q&A function on Zoom. Let me start, Professor Chen, by calling attention to something that you argue in your recent book, Pursuing Citizenship in an Enforcement Era, which I would highly recommend to anyone in the audience, published in 2020 by Stanford University Press. In your book, you note that formal citizenship is necessary for equality in the United States. But then in your law review articles that you mentioned on political misrepresentation in the NYU Law Review and the Colorado Law Review, and throughout your remarks today in the lecture, you show that even when individuals have that formal citizenship, which you've said is a necessary condition for equality, that their voting rights are not necessarily equally secure. And I'm wondering if the phenomenon that you've talked about, the current spate of regulatory restrictions that a number of states are placing on voting rights or considering placing on voting rights, whether it's voter ID requirements, limitations on mail-in voting, and the like, do these voting restrictions effectively create new categories of what you also call in your book semi-citizens? And I think there you're referring more to people who don't yet have the formal citizenship status, but nevertheless are well situated and part of the communities in which they are living and contributing. So anyway, do these voting restrictions effectively create a group of semi-citizens, even from within the category of individuals who possess formal citizenship rights?
I think they do. I'm not the first or only person to say semi-citizens, although it is an animating idea in the Pursuing Citizenship book you talked about. Elizabeth Cohen is a political theorist who also looks at citizenship membership theory and puts forward that idea. And I find it really powerful because I think what it points to is a unifying thread in the experience of racial minorities, such as Black voters who have had, a century of struggle under the effort to enact the Voting Rights Act and to protect it or resurrect it, as the case may be. I think there's a real continuity between that experience and the kinds of experience I focus on today with Latino and Asian voters, many of whom are literally along that citizenship spectrum, right? They're semi-citizens in the sense that they may be here in some kind of lawful status. They may be a permanent resident. They may actually naturalize, right? It shows that there isn't just this binary between being a citizen and a non-citizen. You can be a semi-citizen and you can move across that boundary. And I do think that these voter ID laws end up creating other kinds of hierarchies, right? And so I think that's essentially what we're talking about is this racial hierarchy that's being created. And again, mind you, at the moment, I'm not even talking about the more bold proposal that non-citizens should be able to vote in certain local elections if that community chooses to allow them to. I'm talking about the eligible voters, right? Mm-hmm. Are just facing barriers because of how difficult it is to prove their eligibility.
Yeah.
And, I'm a US born citizen. but my name, Ming Hsu Chen, often puzzles people because it wouldn't always pass a matching surname piece, right? I don't always use the Hsu. And so sometimes, Chen might show up as my last name. Hsu might show up as my last name. I got married in New York City and simplified my first and last name at the same time. And I remembered how hard it was to even get a non-driving ID so that I could ride the subway in New York. And so, there are those who come from foreign-born populations, people like me who are in fact Asian American, but have the surnames that come from a different cultural background that are going to have a harder time getting through these laws, even though they are legally entitled to vote.
So let me turn to a question from a member of the audience who's asking about an argument and wondering how you would respond to it. Some people would say that as a general rule, not in every case, of course, but as a general rule, non-citizens, the argument would go, are less knowledgeable about political issues than citizens who have generally lived in the country longer, been educated there, and undergone the naturalization process. And that difference does that justify the limitations on non-citizens, keeping them from voting?
So I think that we'd have to start with the premise there, right? And whether it is actually the case that non-citizens are less knowledgeable about political issues. I'm not going to dig into that. If we just hold that as hypothetically true, although again, I'm not sure that it always is in this global world where you're going to have very well-informed non-citizens in the United States. And in fact, you could have non-citizens who spend decades legally in the United States, albeit on temporary statuses. We don't require that US-born citizens be knowledgeable about political issues in order to vote. So as a legal matter, if that premise were true, it would still be a legal double standard to make that the case. My other response would be that, if this is a problem, if we wish that US-born citizens and naturalized citizens and non-citizens were all more fully informed before they cast their vote, we would instead invest in citizen education. Right? And this might be a quaint, it's actually a very conservative idea, this idea of civic education and virtues, and thinking about ways that we can make institutional affirmative efforts to encourage an understanding of what the shared values might be, what knowledge might be important, to understand the importance of the process of political participation, and then of course to actually understand the substantive issues that are at stake in a candidate debate or in a particular piece of public policy. So we could lower the bar, sort of have this race to the bottom, where we get rid of the double standard by saying, well, if US-born citizens don't need to know this, then naturalized and non-citizens don't either. Or we could actually try to lift the bar, right, to have a more informed and robust democratic society. I would vote for that option.
I also wonder what the voting participation levels are as between, say, naturalized citizens when citizenship is a requirement versus those with birth citizenship. We do know, of course, that voting participation is low, very low in the United States relative to other countries. Part of that is structural as well. The regulations around voting during the week, people having to take time off of work dampens participation and has a systematic skewing as well, right?
Mm-hmm. Right.
Yeah. So another couple of questions here from an audience member asks about whether states that are passing non-citizen voting laws, and by that I assume they mean laws that would allow non-citizens to vote, the 11 jurisdictions in Maryland, for example, does the Supreme Court's backing out of the electoral law space, whether it's in the Voting Rights Act area that you mentioned or in the area of political gerrymandering, Is there a relationship there? Do you think that this movement, if it's fair to say that the movement toward non-citizen voting is sort of fueled by a disaffection with the Supreme Court's retreat from protecting voting rights and protecting political and racial minorities in the electoral process? And then the related question from this same member: how does the so-called independent state legislature doctrine play into your perspective?
Let me start with the first part. So the Supreme Court has always been okay with partisan gerrymandering, right? It's just racial gerrymandering that is a problem under the law. Of course, there's a close correlation between political gerrymandering and racial gerrymandering, and I took that to be a significant part of the point that Professor Charles was making in this distinguished lecture. And so I can't say for sure whether the states that have passed these non-citizen voting laws and the municipalities that have, whether they're fueled by it, right? I have a PhD in a social science subject, so causation is a term of art. I can't say it causes it, but I will say it may help to ameliorate the destructive effects of a court being unwilling to investigate gerrymandering that will have racially disparate and unequal outcomes. So I think it can help to ameliorate it. It goes to this question of how you're going to be able to create any kind of change, right? You're not going to see it through the courts for the reason I talked about, and also for the reasons that this audience member is suggesting. But the Supreme Court has decided increasingly to be hands-off. They're not even going to review these cases, let alone decide in a way that would be consistent with this more inclusionary vision that I've painted. So if you're not going to see through it courts, where are you going to see it? You're not easily going to see it through the legislatures either, right? That's that double harm. And so I do think you have to start to think about ways to build power in communities. And some of that will be through things like this non-citizen voting and some of the other measures I mentioned.
Excellent. And that leads us to the final question, really leads right into it. Two related questions, I guess. One is essentially, is what you propose realistic? Citizenship or civic engagement by those who have maybe been demobilized due to continuous and sometimes intergenerational exclusion from political representation. How do we overcome that historical oppression in the political sphere? And maybe a flip side of this is a more hopeful question. Can you recommend some ways to help empower these individuals if they are clients of some of our audience members, for example?
So I think that it is hard. I don't think that means it's impossible. I think that it does require, first and foremost, starting to rebuild that trust. So you can make the mechanisms, right? And that's what lawyers can help do and what politicians can help do. But in order to have people avail themselves of any of these techniques we've talked about, you do have to build that trust, that investment in a community. And so I think some of that might come from recognizing these linked fates that I mentioned, and understanding that the community as a whole benefits and not just the non-citizens themselves. So there's an incentive on both sides to invest in the community, right? Again, this idea that the rising tide lifts all boats. And then I also think that there's a need to be creative in thinking about ways that this kind of power can spill over from the localized efforts, things like school districts, to federal politics, which is probably the place that's going to be the hardest to reach. Right. And so I think that is going to be a matter of building momentum and then needing to find ways to harness that so that there can be change piece by piece that can add up on the national scale.
So no quick or short-term fix per se, but Robert Reich, who wrote a book called The Power of Public Ideas, maybe onto something here. The ideas of inclusion, equality, these are powerful ideas. And I want to thank Professor Chen. I want to thank you for being here today and sharing these powerful ideas with us, informing us and inspiring us. I want to thank all of the members of the audience for being here and wish you all a good evening. If you would like, go to our YouTube channel and you can listen to all the other lectures in our Race and Regulation lecture series this year. And we will have a forthcoming podcast later this year that brings together the insights from all of our speakers as well. Again, thank you for Professor Chen for being here. And if we were gathered physically, we would be giving you a very rousing round of applause and our sincerest thanks. Have a good evening.